I have the pleasure and honor of serving as the Notre Dame chapter president for ACS. So at Notre Dame, we pride ourselves at producing a different type of lawyer. Now, that really varies from student to student, but for me, it means a stellar dedication to justice, equality, truth, and creative thinking in every aspect of my work. As a first-in-family, diverse lawyer, I recognize that I think a little bit differently about problems, maybe outside of some of the conventional wisdom. Now, that doesn't necessarily mean that we get to entirely deviate from that conventional wisdom, but it means we get to add. It means we get to do more. It's hard to be a good advocate, but at the end of the day, results are attainable. Attorneys should write well, show up on time, perform due diligence, protect the rights of clients, and remain professional. All of that is part of our very proud legal tradition, but being a different kind of lawyer requires more. Sometimes that means that we're going to lose some battles in order to win a war. Today's panel is going to discuss just that, what it is to do more. Through scholarship, media savvy, community organizing, and legislative advocacy, we will ask what attorneys must do in today's America to do more for their clients to produce the best results. Leading us on that journey today will be Jeryl Hayes, from the Movement Building Director at If, When, How, a national network of legal professionals and students supporting the reproductive health care rights. As a movement building director, Jeryl shapes movement building strategies, grows and evolves programs, and oversees the mobilization and networking of law students and professionals to champion reproductive justice within and beyond the legal system. We thank Jeryl for joining us here today and imparting her wisdom. Without any further ado, and with a warm round of applause, please welcome Jeryl Hayes.
Good morning. Can you all hear me? Oh, here we go. Good morning. It is my pleasure just to get to moderate such an incredible panel of folks up here we're going to have a great conversation about what it means to move beyond traditional lawyering. As was mentioned, my name is Jeryl Hayes. I'm the Movement Building Director for If, When, How, Lawyering for Reproductive Justice. This is an organization that is near and dear to my heart. I first learned about them when I was a law student back in the early part of the last decade. And it's an organization that is really focused on changing the way we think about lawyering when it comes to issues related to reproductive justice and reproductive autonomy. And particularly given the current administration and the unprecedented attacks that we have seen on access to the full range of reproductive health care, including access to contraception, abortion, and maternity care, we really have to be creative about how we think about lawyering and what that means under the current administration. Our legal system was not necessarily designed to bring justice to everyone who is trying to access it. So particularly as progressive lawyers, we really have to look at the different opportunities that there are to expand the legal system and make sure that everyone has access to justice through the legal system. So that means broadening our concepts of what it means to lawyer, to help advocate for clients, and to help change hearts and minds, and especially when we're addressing some of the major issues that are coming up. We will be feeling the effects of a more conservative judiciary, especially under this administration, and knowing the changes that may be coming with the Supreme Court, with some potential retirements that may be happening. We cannot just be holding on to the health of Ruth Bader Ginsburg. That woman deserves to take a break every once in a while. So we need to be really strategic about thinking about how, as progressive lawyers, we really want to make sure that we are shoring up the opportunities that we have. And so with that, Actually, before, I just realized I didn't get to mention this. If you are all using social media, which we encourage you to do, please use the hashtag ACS2019. Because we have such an incredible group of panelists, we want to make sure that we are uplifting their wise counsel that they are providing. So please be sure to use that hashtag. I'm going to have our panelists introduce themselves and take a few minutes to just talk a little bit about their journey. And then we'll get into some specific questions, and then we will have plenty of time to have a conversation with you all. I've got a long list of questions here, but I also want to make sure that students get an opportunity to ask their questions. So we'll start with Garrett.
Thank you, Jeryl. Thanks to everybody. I'm really tickled to be here for a couple of reasons, the most important one being that I think the progressive legal battles that will be fought in the early part of your generation at least will be won or lost by the strategies that are indicated up here. We can't count on the courts to do justice. We can work to frame the situation the courts respond to. But before I tell you about myself, I have to say, having for the first time been invited to speak at the University of Virginia, I have to give a shout out to my late father, A.C. Epps, senior class of none so great as 38, who told me very proudly late in his life that he thought the law school was the best place in the world because they'd found a way to name the new building after 4 different people, depending on which entry. And each person paid quite well for the rights. And coming here, I realize it's true. He was right. So I bear his memory in mind. My story is kind of unusual. I was a professional journalist for 15 years and went back to law school at the advanced age of 38 and now teach constitutional law at the University of Baltimore, but I also am the Supreme Court correspondent and contributing writer for The Atlantic, and so I spend a great deal of time immersed in the sort of day-to-day coverage of the courts and what's being written and what's being said on the media, and have some fairly serious thoughts about what each person in this room can do as a progressive lawyer to change and shape that environment and how important it is. And I will talk about that later, but now I'll hand you over to Andrew.
Thank you. Good morning, everyone. With many thanks to the ACS team, Jeryl, and my fellow esteemed panelists. It's such an honor to be here. My name is Andrew Hairston. I'm a staff attorney at Advancement Projects National Office. It is a racial justice organization that has been around since 1999. I was joking with a few folks this evening or later on, last evening and early this morning, that I am a K through JD person, did not take a break from kindergarten through law school. Yeah, that is how I have arrived here. So I went to Howard University for undergrad, went straight to LSU Law School in Baton Rouge, and then started a 1-year postgraduate fellowship at the Lawyers Committee for Civil Rights Under Law, where I supported the organization's Educational Opportunities Project. And then soon after I finished that fellowship, joined at AP, Advancement Projects National Office, where I support the Opportunity to Learn program at the organization, as well as the Power and Democracy program. And I'm really excited to talk about the model of community lawyering, and just as Jeryl and Garrett have alluded to, the idea that traditional litigation is not, the end-all, be-all for this generation and for this movement of progressive lawyering, and thinking about really uplifting directly impacted people on the ground and making sure that working with them really elicits a partnership that is genuine and authentic and is serving them in the best way possible.
Good morning, everybody. My name is Amy Woolard. I am an attorney and policy coordinator for an organization called the Legal Aid Justice Center. We have an office here in Charlottesville, which is where I'm based, but also Richmond, Northern Virginia, and the Petersburg area. We're a bit of a non-traditional legal aid organization in that we really emphasize kind of a 3-prong approach to how we address the needs of low-income clients, and that is through direct service, of course, but because we are a nonprofit, we also have a pretty strong community education and community organizing arm, and we have a sort of complex major litigation and policy arm as well. and I mostly focus on our policy work. I do all of our work at the state level with the governor's office and the General Assembly here in Virginia. You may have heard about them recently. A little bit of federal work, and we also do some policy work at the local level on some issues there. I think of all of us, I might win for the strangest path. I went to UVA undergrad and came out and did a creative writing degree. Worked in restaurants for a very long time, full time. And then became a journalist, much like Garrett. And from there went on to law school, and through a fellowship project really got involved with policy work as a component of direct service to low-income clients, working on things like foster care advocacy, juvenile justice, all of our children's law issues, and then have since expanded from there to help out in all of our programs, which includes immigrant advocacy, some economic justice work around employment discrimination, wage theft, things like that. And also, we recently started a civil rights and racial justice program where we look at things like community policing, transparency around pretrial detention. Well, if you come to our breakout session a little bit later, I'll talk about how we've been working on the issue of court fines and fees in the legislative context. And my major soapbox is and always has been pay attention to the state level, get involved in state level legislative work and administrative work, because those are where the laws really hit the road and hit the communities that we care about most harshly. So.
Thanks. My name is Micah Schwartzman. I'm on the faculty here at the law school, and I think my path into academia is fairly traditional. I went to UVA as an undergraduate and then did a graduate degree in political science. Was sort of a philosophical bent, and then I came back to UVA for law school, and then I clerked, and then I came back to UVA. It's like a tractor beam. Once you're here in Charlottesville, you can never get away. So you're already here. It might be a problem for you leaving. So I'm on the panel to talk about the role of scholarship in advocacy and to think about how legal academia especially can play a role in thinking about liberal and progressive legal advocacy. I can't say that I came into the academy with an eye toward advocacy. I mean, my scholarship is fairly traditional. I came in writing articles for peer review, for law reviews. Before tenure, I don't think I'd co-authored anything. I hadn't written op-eds, which is probably a safe strategy. But especially in the last few years, I've gotten involved in some forms of legal advocacy. I've helped to organize and to co-author amicus briefs in cases like Trump v. Hawaii, the travel ban case, Masterpiece Cake Shop, and some follow-on cases. We're working on a brief in Arlene Flowers right now, which is another wedding vendor case. I've done some work with a team of church and state scholars. I think that team probably was mobilized in part by the litigation over Hobby Lobby. And we've worked with Joshua Matz and Robbie Kaplan and some other progressive lawyers to try to bring the expertise within the scholarly community to bear on some of the legal questions that are in front of courts. And in doing that, we've been thinking about the relationship between scholarship and advocacy. What are some of the virtues of scholars getting involved in litigation as amicus or directly, and what are some of the risks of doing that, and how do we think about the role of scholars in that regard? I do this kind of work on both sides, on the scholarly side and in litigation, and I think it's worth defending the participation of academics inside various advocacy roles, and I hope we'll have a chance to say more about that.
Great. So each of these panelists are up here to talk, as they already mentioned, about specific areas, and they will each be participating in a breakout session at the end, and we'll announce where those are. But just to get a little more into the details, so we'll start, Garrett, with you, and talking about media engagement. So students spend a lot of time writing in law school. How does or does it not prepare them for writing and messaging to non-legal audiences? And why does it matter that we need to reach non-legal audiences?
Well, I'll start with a story that my brother John told me about his first day of law school, which was in the 70s when a movie called The Paper Chase was quite popular. And the professor came in and said, how many people have seen The Paper Chase? And every hand went up, and he said, well, you know how John Houseman says, you come in here with a skull full of mush, and if you survive, you leave thinking like a lawyer. And they said, yeah, we're terrified. He said, actually, you come in here thinking, reasonably well, and if I succeed, you leave with a skull full of mush. And I think the real point there is that law school, for all its virtues, and I'm a great proponent of law school, actually unfits its graduates, unless they're very aware about this, for communicating with audiences that are not legal. And, for that reason, for example, I have started, and some other schools have started, seminars in nonfiction writing for law students who want to reach the public. Because the precise virtues of lawyers, which is the ability that they have to concentrate, to hold in their minds a number of points, and so forth, can lead them to be very intimidating and, let's be frank, boring when they try to communicate to the public. So it is worth retraining yourself. It is worth bearing in mind as you try to learn to communicate in law school that as a practicing lawyer, whatever it is you're doing, the public is going to be terribly important to your efforts. And the ability to represent your causes and your clients to the public can make or break the success of a given enterprise. And that means learning certain things about how people absorb information. It means, when I broke in as a journalist, which was in the old days when the New York Times was written in English, they had an editor named Ted Bernstein who used to write OTPS on people's stories. That was when stories were written in paper. And that stands for one thought per sentence. That's the way people absorb information. And that's true whether you are presenting in writing or in a plastic medium, in film, radio, whatever. Give people time to absorb the thoughts. Give people time to go with you where you're going. The other thing is to understand the importance of narrative. Narrative is how people learn. Narrative is how you draw people into your stories. And we will talk more about this in our breakout session for anybody who wants to come. But the final thing I want to say is I don't think there's ever been a moment in my lifetime when the legal narrative was more clearly up for grabs. And when we, that is we as progressive lawyers, had such an opportunity to seize it and shape it and make it something that will guide us through the strategies we're talking about here and others to a better situation than the really bad one we find ourselves in now. So I'll leave it at that.
Well, as a follow-up, can we talk a little bit about social media, especially in the current under the current administration and sort of the role that social media does play with folks getting information? How have you seen the change in social media and how people absorb that information? How has that changed?
Well, there's two things going on in social media as I see it, right? And one is, and I approach this in part, as part of an organization that is the Atlantic Online, which is very effective in promoting itself on social media. And secondly, as myself, as someone who is writing, I write probably at least once a week about what's going on in the Supreme Court or elsewhere in constitutional areas. And I really would like that to be to be read. And so that's an important aspect of social media. The other aspect, of course, is that Twitter in particular is it's as much as we know on earth as hell. and it can be a very toxic environment. So in order to use it effectively, you have to maintain a critical distance, but you also have to maintain a consistent engagement. And one of the things I do, for example, when I publish a piece, is that over the next 24 hours, I retweet the piece at least 4 times with different intro material. I mean, at first that felt really gross, right? Hi, look at me. I wrote the same piece again. But in fact, on the Twitter sphere, you have people dialing in and dialing out at different times of day. And so it's very important to keep things going on. The others is to try to, the 2 other things is, 1, try to introduce some element of originality, some element of humor. Probably the most successful tweet that I've ever written just came to me, and it was a limerick. And it said, the president wanted a wall, concrete, imposing, and tall, but his sense of urgency is not an emergency. Perhaps it will hasten his fall. And, I just dashed that off, and it got, like 1,000 retweets, and it picked up, followers, which is what you're looking for, right? So try to attach yourself in creative and engaging ways to what's going on. Don't just retweet Trump is a jackass, Trump is a jackass. There's plenty of that out there, right? And the third thing is, don't feed the trolls. It's bad for your soul. Social media is a tool. It's not an environment you want to live in. I've always wished I was important enough to have the intern do my tweeting for me, because then I could get done what I wanted to get done without having it corrode my soul. So you have to be very, very careful about that. And Twitter, it may be passing from its pride of place. We're now looking at Instagram, for example, and creative use of Instagram and people as influencers. And those of you with interest in graphic arts and photography can make incredibly powerful use of things like that and video on Facebook, on Instagram, and which brings to me finally, first of all, you can acquire these skills, but secondly, a lot of you come to law school with really amazing skills that can be applied to that environment. And one of the things I always say to entering law students is the purpose of law school is not to make you less than you were when you came in, right? You will remain the things that the skills that you have. Use them, apply them. And social media is a very good area to do that in.
Thank you very much. So now let's talk a little bit about community organizing. So Andrew, can you explain for folks who may not be as familiar, what is community organizing and how does it fit into legal advocacy?
Absolutely. To give more context on my answer to this question, I'll talk about the history of Advancement Project a bit. So as I mentioned in my introductory remarks, it was founded in 1999 by veteran civil rights lawyers who felt like litigation was the end-all, be-all, as I mentioned, and that it was being used in a way that was really elevating, the organizations that were bringing the lawsuits, but perhaps not really engaging with the communities who would be impacted by the decisions that would come from these court orders. So with AP's founding, this idea of engaging legal policy, communications, and organizing tools to advance the unmet goals of the civil rights movement really materialized as our mission and as our goal as an organization. So with that, community organizing for me, and particularly as a lawyer, feels like engaging in those deep partnerships with community-based organizations on the ground, and ensuring that in all that you do, that these impacted voices are elevated, right? AP is a racial justice organization, but we also recognize the intersections of the LGBTQ experience of differently abled folks, right? And ensuring that as we are engaging in our advocacy with our community partners, we are ensuring that the community-based organizations get the light, they get the shine, get media opportunities, fundraising opportunities, but also that we are really being genuine, legitimate thought partners. For AP, that has looked different over the past 20 years. For me, as a staff attorney who supports the Opportunity to Learn program, I think our school-to-prison pipeline work provides a good case study. So, at the turn of the millennium, folks were recognizing the harms of zero-tolerance policies and the war on drugs and how that had spilled into schools, and recognized that these were very militarized environments for young people, particularly black and brown young people. And so there was a push to try to get rid of these zero-tolerance policies across the country and figure out how to do that. So Advancement Project's Opportunity to Learn program started working with community-based organizations in Denver, in Buffalo, in Miami, and really thinking about ways beyond litigation that these achievements could be accomplished. And a strategy was identified of working with the school districts themselves, certainly working with the community-based organizations and collaborating deeply, but getting into conversations with the school districts to reform the codes of conduct that govern student behavior and discipline. So we got a few wins in that regard, particularly in Denver and Buffalo, a shift from some of that harsh zero-tolerance language to more restorative justice themed language, encouraging more peace circles and such. But then we saw there was very little motivation to implement these changes, and that has, provided an opportunity for us to stop and reflect and say that was good. We are proud that we contributed to the revised code of conduct, but how do we continue to ensure that the experience of black and brown young people in school is a holistic one that cultivates their passions and their interests? So all of that to say, community organizing is an expansive term, particularly for a progressive lawyer, but it's one that means really being in partnership with those organizations or those clients that you represent, and ensuring that they have their voices heard, and recognizing that even when you do get some victories, the battles will remain, and those partnerships should persist.
Thank you. And just, thinking about those specific partnerships with grassroots activists, can you talk a little bit more about the importance of having that perspective on the ground, especially on those issues, making sure that you are actually engaging with the community that is most impacted by the laws that are trying to be changed, the different types of policies? Can you talk a little bit about that voice of the folks who you're trying to, who are the most impacted?
Absolutely, yeah. I think it comes with trust, right? Like in any friendship, any relationship, and at AP, we really try, not even when it's just, litigation that might be on the horizon or a big, detrimental policy push that's coming from a school district. It's like, it's March, we haven't seen you in a while. Let's go out to Denver, break bread, and strategize about what the next 6 to 12 months will look like. And I think building that legitimate trust and recognizing that you are professional partners and that you're friends with these folks on the ground allows you to be a strategic consultant to them, and ensure that they trust you in the advice that you give, and that as you prepare them for media interviews or for presentations in front of school boards or elected officials, that the voice that they have, that really fundamental voice, like Garrett said, that you have, despite what your experiences may be, is elevated, and that you as a progressive lawyer are really just helping them out with making sure that their voice is heard as grandly as possible. That trust is just so paramount.
Thank you so much. All right, so Amy, let's talk a little bit about legislative advocacy. And this is an issue that's near and dear to my heart. I've done years of federal reproductive health advocacy, so that's not...
Solidarity.
Yeah, that's not challenging at all. So can you talk a little bit about the difference in advocating in the courtroom and how that is different than advocating in the legislature?
Sure. Well, first I'll say this is This is actually the last day of the Virginia General Assembly session today, so if I'm nervously checking my phone, I still have a couple of bills in conference that I'm waiting to see what's happening. As far as the difference in sort of representing individual clients and what I do at the GA, they are worlds apart, but they're kind of inextricable as well. In the courtroom, I have one client to serve. I have their express interests. They have some discrete issues that I can attempt to solve. Usually, it has to happen within the confines of existing law, or perhaps, if it's a larger issue, we can challenge the law itself in certain ways, but we're sort of operating within an existing structure and the barriers of that structure. And that can be the kind of situation where, if you're an emergency room doctor and one person comes in with a broken arm, you might treat it, set it, send that person home and not think about it. But if 50 people come in with a broken arm, you might actually have what is going on? Why is everyone breaking their arm? And it might be a better use of your resources and your capacity to kind of figure out what's going on with the larger problem. And that was really the attraction to policy and legislative advocacy for me. We have young people coming in the door with the same problems over and over again. The current law does not work for them. Our criminal justice systems, our school discipline systems are set up to enact racism and enact classism against the communities that we represent. And so to make real change for those folks, to be able to send them back out the door and feel good about that, I think that it's incumbent upon organizations that do direct service with clients to at least have, dip their toes in the water of policy, to have partnerships with organizations that are working on policy and legislative advocacy, or to do it themselves. With policy work, I get to change the game entirely. I get to put new pieces on the board, I get to take pieces off the board, I get to change the rules of the game. And once you start working in a legislature, or, Jeryl, working on the Hill, once you get in there, you realize there really is no access for the folks that we represent to be heard there. There's sometimes, literally no physical access. It is hard to get in the building and get in these committee rooms and stand up before a committee. And it's even harder to have the expectation of folks to kind of lay their lives out and essentially make themselves vulnerable for an attempt to change something that they have been told their entire lives was a moral failing, when really it's a structural and legal failing that they are coming up against.
And in your intro, you mentioned the importance of paying attention to what's happening at the local level, especially in the context of policy and advocacy. So how do you balance between, working at the micro and at the macro level?
I mean, it is really difficult. I will say that most of my time now is spent at that macro level. My caseload is much smaller than other attorneys in my shop, and I mostly consult on other cases, but they really inform each other. When we're working with individual clients, we're discovering broader issues that they're facing, and part of the strategy, it may not end up helping in their individual case, but it's going to help dozens of kids or dozens of clients like them. And it is really humbling to talk to some of our clients and have them almost always so willing to put themselves out there for other folks who might be in their same situation, even if what we're working on won't sort of help their specific problem directly.
And then just as a follow-up, which of the venues do you think, where do the wheels of justice, I guess, move more swiftly? And if you were to focus on one versus another, would you be able to sort of weigh them in that way?
Yeah, we'll be transparent. There is nothing swift about policy work. It is a marathon. It is performing a sprint in the distance of a marathon. You have to be willing to lose year after year and keep coming back. You have to get creative with your strategies. A lot of times, we don't just have a piece of legislation moving. We have complex litigation tackling the same issue. We're continuing to serve individual clients at the same time. We have media campaigns, we have organizing campaigns, and all of them have to talk to each other and work together and keep pushing forward. And, you know, it can be a tough pill to swallow to think that you are moving incrementally, but you have to kind of be able to take that 35,000-foot view and see that each step that you take is part of a larger whole. You know, with policy work, with anti-poverty work and racial justice work, you're essentially having to rebuild an entire building while there are people still living inside. And that is a daunting task, and it is a long-term task, and it can be an abstract and esoteric task. Legislatures, I mean, I've only worked in the Virginia legislature, but I'm guessing it's a pretty good test case scenario. It's the Wild West. There are no rules there. You go into a courtroom and you think, I can present my case, and there are civil procedure rules to follow, and the judge is going to listen to my side and the other side and kind of weigh the law. In the legislature, your bill can die because someone had a bad breakfast that morning. And you just have to live with that and work within the rules that are given to you there and try to use them to your advantage.
Thank you. So switching gears a little bit now to legal scholarship. So Micah, can you tell us a little bit about traditional legal scholarship, including what audience are you typically trying to persuade there?
Yeah, so that's a great question. I was thinking about that as I've been listening, because the audiences that we're talking about are so different. Like Garrett's talking about social media, and the audience could be hundreds of thousands, millions of people out there, faceless. There are huge, potentially huge audiences. Sometimes we're focused on smaller communities, sometimes at the legislative level. So who are academics talking about? So sometimes I think I'm talking about a group of people who might fit into the first few rows here, right? Just a handful of experts who are really specialists in a particular topic, and the arguments are narrow and refined and expert, in this kind of highest level way. Sometimes the audiences are much broader. We're trying to communicate those ideas to the public in the way that sometimes journalists do. Sometimes we're trying to translate these ideas for judges and for legal experts in the context of writing amicus briefs. But I think the traditional law review article is mostly, if we're trying to be realistic about it, it's mostly written for other legal academics, and it's a small universe, relatively speaking. And so part of the challenge for people who are engaged in scholarship and legal advocacy is translating those ideas to broaden out the community of people who can understand and read them.
So what advice would you then give for students and new lawyers to be able to use legal scholarship to advance their goals?
So I think one important question to ask here in response to that one is, what's your added value? Right? You could do lots of different kinds of things in the world. You can be a journalist, you can be a litigator, you can be a community organizer. There are lots of different roles that you might have in the way that you engage in legal advocacy. And if you're a scholar, what are you bringing? And I think the answer, I think there are really two answers to that question. One is that you have more time to think about certain questions, and that comes from specialization. So if you're thinking about doing scholarship in the light of advocacy, it's that you should develop some kind of expertise in an area, and expertise comes with time and commitment. Right? That you have time to bear down on a question in the way that other people simply don't. When I was just coming out of law school and talking to lawyers about their careers, you'd sometimes get the feel from trial litigators that they didn't like appellate litigators very much. And that was because appellate litigators have more time to think about all the small decisions that, the trial litigators had to make very fast. They just didn't, and they're second guessing them many months later, years later, and then, they're expanding out. And you'd get the sense from appellate litigators that they didn't like academics very much for the same kinds of reasons, right? You'd spend 2 months working on a topic, and some academic had spent 7 years working on the same question, right? And bringing that to bear. I mean, I think the answer to this question is partly that. You have time, and how are you going to use it? And then how are you going to translate the fruits of that labor and that expertise into ideas that other people will find valuable in the various spaces in which they're working? And I think scholarship has that opportunity to see problems that other people haven't seen because they haven't had the chance or the opportunity to work out as systematically as you might have, where there are risks, where there are problems, where there are missed opportunities, and to shed some light on those.
Yeah, and in that vein, how has scholarship been used to sort of develop more of those outlier legal theories and bring them more into mainstream. I feel like the other side has done this pretty effectively.
Yeah, so there's been a lot of conversation about this, the role that academics have played in promoting specific legal ideas in litigation. Think of, for example, Randy Barnett's work as I'd call him a kind of legal entrepreneur. Barnett is a professor at Georgetown, but raised some libertarian arguments initially in the context of medical marijuana in the case called Raich versus Gonzales, and then in NFIB, the healthcare cases, right, pushing an argument that the government didn't have authority under the Commerce Clause to legislate the healthcare mandate. And those arguments people thought were crazy arguments. Right? They just had no traction. And over time, largely I think through the use of, well, what was then kind of burgeoning social media, but thinking about blogs, they're so passé now, right? Nobody blogs anymore. But using blog, and to develop arguments with speed. And I think this is one very important way in which modern media has changed the nature of the relationship between scholarship and legal advocacy. Arguments are developed much faster than they used to be. I mean, it's possible to air a big idea and to get counterexamples and counterarguments and then develop responses to those and then further all of that very fast. And to see those arguments develop so quickly, I think can change the course of litigation. And let me just give, if I have time, one example of that, which is a recent example, which is the arguments in the Hobby Lobby litigation, right, involving the challenge under the Religious Freedom Restoration Act to the contraception mandate. And what you saw in that litigation, right, that case went from preliminary injunction to the Supreme Court in about a year. Right? That's very fast. And the nature of the arguments that were presented in that litigation changed dramatically over the course of it. The government started out saying corporations aren't people, and for that reason, they don't have rights of religious freedom. And by the time the case got to the court, it was pretty clear that argument was going to be a loser. And other arguments had to come into play. And some of that got filled in by, I think, by scholars who said, look, if these arguments aren't working, there are some really important considerations that aren't in play here. And I think most importantly, that litigation involved a challenge from corporations to the government. And there were people left out, namely employees and women who were going to be directly affected by the rules that were going to be made in that case. And no one was representing them in the litigation. And some academics took up that role and to say, look, there are important interests here and there are powerful arguments to represent those interests, and we have to make those arguments and make them clear to the litigators who are presenting these cases. There is a role to play for people to identify interests that haven't been articulated and to try to do that, but have to do it in a timely way, and then I think you have to be ready to engage. Yeah.
Thank you. So we've talked, so these will now be sort of broader questions for everyone to answer. So we've talked about working within the sort of constraints that our current legal system is, and for many folks, the system wasn't built for them. If you were to be designing the legal system from the ground up, from a progressive viewpoint, what would be different, and how would law schools work differently to sort of serve that vision?
Building a system from the ground up.
Yeah, and that's for everyone to sort of think on and answer.
Well, if I could just take a quick stab at that, I think that I'm not a structural law person, but I think that if you look at the area where we really see some fairly important and exciting change taking place, which is in criminal justice, a lot of that comes about not just because of the efforts of lawyers and advocates, but because the larger public got involved. And if I could redesign the way we talk about law, the general public would be much more involved, would be much clearer on what we're talking about, what's at stake. And to the extent that lawyers and advocates can make that happen, can reach out, that makes a huge difference. And just following up about scholarship, the thing to understand about scholarship, if that's what you choose to do, is that, it really does actually reach all the way down to the way people read about or see law on television, because reporters and commentators, they read legal scholarship and they call legal scholars. If you can get your work out there, it's not enough just to publish it in a law review, but push it out there, let people know what you're working on. Legal blogs are really still quite important, although the blog as a form apparently has lost its trendiness. So those are the two things I would say.
I have a whole list, Jeryl. Our public defense systems need to be fully funded. People who have their housing and education and families threatened need to have legal representation. We see this time and again. We have law after law that favors corporate and financial interests over individual basic needs, simple needs like food, clothing, housing, education. As I said before, our criminal justice system is set up still to enact racism. The Washington Post banner is democracy dies in dark, like people are dying in darkness because, they're dying in our jails and our prisons because we don't know what's going on inside of them, because we don't have access to them. They're dying in streets because of policing, and all of that is propped up by our current legal system. How it can feed into law schools, I think that folks need practical experiences. This is not to suggest that students' own experiences don't match some of what I've just talked about by any means, but I think the more that we can get students connected to clinical experiences in anti-poverty and racial justice work, that is going to serve you no matter what you do.
Yeah, a very quick one. I would just reduce the financial obligations associated with all parts of the legal process, right? It is just, and this is my broader reflection on capitalism, but but yeah, it is prohibitive in so many ways. The idea, as Amy just suggested, that you cannot access representation for such basic human needs is just ludicrous.
My one main thought here is that you should not expect law schools and law professors to do the work of building a progressive legal movement. I think the idea, sometimes on the left, when you hear, why don't groups fund ideas, fund think tanks, fund work in building a scholarly base for advocacy? And the answer that you get from some philanthropists is, well, universities already do that. We don't need to fund those kinds of projects because that's what universities are for. And I don't think that's what universities are for. And I think it's a mistake to think that law schools are going to do this kind of work on their own. It's something that has to be built out by organizations like this one, and that progressive lawyers are going to have to make a commitment to. There's sometimes this idea that you won't get and you won't attract funding unless you have ideas. But the argument works in the other way too. You won't build out ideas over time unless you have people who have the resources to develop them and to make them attractive and coherent and more comprehensive. That takes funding, and we have to have a commitment to it outside the university.
So I've got one more question before we open it up to the audience. We do have an audience full of future lawyers, future judges, future politicians, legislators. So what advice would you give to students in terms of how to use their remaining time in law school to really prepare them for working in this field?
Yeah, absolutely. The K through JD, right? The closest to, closest removed from law school. Just as Amy suggested, the clinical experiences are critical. I think my experiences in law school through clinics, or parole clinic I did, juvenile defense clinic I did, made me really think deliberately about racial justice work and anti-poverty work and how it informs my career as a progressive lawyer. To Micah's point, kind of getting involved with the journals and the publications that interest you and having that racial justice analysis as you write your comments and notes. And then to Garrett and his point about that refinement of nonfiction writing and thinking about how you're engaging in audiences that aren't courts, that aren't necessarily judges, but the broader public that this narrative shifting needs to necessarily take place to move some of these victories forward. All those things.
Here's what I would say very quickly, and that is, as you get further along in your legal education, always try to remember what brought you here. And that sounds like a platitude, but it really is not. I, as a journalist, had the opportunity to cover quite extensively the Marine Corps' process of training military officers through their schools, their officer candidate school and basic school. And the aim of military training is to take people who are sort of diverse individuals and really standardize them into people who fit into a military machine and follow orders, because that's the way you can carry on military operations. And, subsequently when I went to law school, I was struck by the similarities between the way law school operates and the way military training operates. It overwhelms you. It gives you too much to do, too much to think about, to remember who you are. And the result can easily be that you come out of law school pointed in the direction that the institution seems in a sort of tacit way to be pointing you toward. So when I was at the University of Oregon, I used to do a thing with students when they entered in orientation. We would take a minute and they would each write down on a piece of paper what they really wanted to be when they came out of law school. And then our staff would collect the papers and they would be in envelopes with the student's name on them. And then the day after first year grades came out, they would get their envelope back. To remember, we have brutalized you, right, for a year, but you're still the person that you were when you came in. So I think that if you remember that, if you just literally, we just had this mindfulness thing, if you just literally stop in the middle of it and say, why am I here? What was the vision of justice that brought me here? Am I moving toward it? How can I take charge of this process? Take it back from the tacit bureaucratic forces that are pushing me in a certain way. I think you will experience more satisfaction, and your career will be more positive if you do that. So that's very important. That's my recommendation.
I think I would just add, sort of as a follow-up to what Andrew was talking about, that this panel is a good indication of the different types of situations it would be good to put yourself in. I think even when students go towards clinical work, you sort of have a vision of like, I'm going to have a client, and that's really exciting, and it's good to get to know your client and work on one case. But if you're doing anti-poverty work or racial justice work, you're probably working in a scarcity context where, we might all be up here talking about specific areas of specialty, but we all probably do a little bit of everything as well. And so I think the strongest students I see that we have come in are strong writers, in the context that Garrett's been talking about and in the context that Micah's been talking about. Can you put something into a paragraph and into, you have to write at this point?
Too many.
70, yeah.
Can you be that nimble with your writing? Can you make compelling arguments in different contexts for different audiences? I'd strongly encourage folks to get some experience in community organizing, because I think that aspect of advocacy is a game changer and is going to only emerge as a stronger component of all of the work we do going forward.
This is all great. I would just add, look for good mentors. Seek them out. Go look for people who have passions, who have ideas they care about, and ask them about their experiences. Ask them, what job did you most enjoy or was most fulfilling for you along the way? What were the things that were important to you at various stages of your career? How did you get from here to there? You have there's a lot to learn from people about their life trajectories, and those are things you're not going to learn in the classroom and you're not going to see otherwise. And if you find good mentors and work hard with them, they will open doors for you and you will learn a lot from them. I think a lot of people, it's easy to get channeled into programs or into professional lines, because law schools are set up to do that, to get you jobs in various kinds of ways. And I think it's really important to try at some point, and it can be work to find good people to talk to, but to go out and meet people who care about the things that you care about and ask them lots of questions.
Can I say something
Yeah,
quickly
absolutely.
to that? And the thing to remember about that, because I think that's a really important point, is you are law students. That in itself is an achievement, and people are interested in you, and particularly in the field, people do want to give you information and help and guidance. Don't be ashamed to ask for it. I remember when I was spending time at the University of New Mexico, there was which is a small state, but there was a student there who was working on a paper that had to do with something in the governor's office, and this student just picked up the phone and called the governor. Right, so I'm a law student at the University of New Mexico. I'd like to talk to the governor. Oh, yes, certainly, and really, and that's exaggeration for a small state, but it does. Remember, you have opportunity, you have agency, you can get to people, and people do want to help you.
We actually use that strategy on purpose sometimes too. Like, I don't know what I'm doing. I'm just calling you.
Great. So now we've got plenty of time for your questions that you have for this incredible panel. Don't be shy.
This question is mostly for Professor Schwartzman and Ms. Woolard, but if the other panelists have something to say, that's wonderful as well. So there's been a discussion around strategy in pushing legal arguments or policy arguments that we as progressives support now, and whether it might not be a good idea to hold back on making some of those arguments while conditions are less favorable, and maybe the courts will strike them down, or our opponents in the legislature will come up with the good arguments, the good strategic arguments against them. Do you agree that we should hold back some of those arguments in these times, and why or why not?
I mean, here in Virginia, we have that happen at the state level all the time. I've worked in Virginia when we've had a conservative governor and a fully conservative legislature. I've worked in a Virginia where we've had a Democratic governor who was not very well liked by the Republican-controlled legislature. I think we're always evaluating those questions. I mean, I think maybe, and Andrew, you know this too, one of the things that has come up in this sort of these current times, federal environment around civil rights and education is, do we file complaints in the education context with the Office of Civil Rights when we have gotten clear indication from the Secretary's office that, newsflash, racism doesn't exist anymore. So do we file those and potentially get bad decisions, or do we not file them and wait? And I think it's a continued topic of conversation among the advocates, and probably the best thing that we do in the organizations that we work for is have these peer networks of advocates who continue to talk this through and kind of adjust as the environment changes. I think ultimately questions come up about, if we're not doing these things, does it send the message that civil rights violations do not exist during this time period? Are we losing some tracking of what's actually happening on the ground if we're not putting it on the page and filing it? So I think we're always evaluating those questions, and it may sort of depend on the particular issue. It's always a factor in, when I think about at the state level, what bills we might want to pursue, or not even whether or not to pursue a particular broader issue, but what are the pieces we might be able to tackle depending on what the political environment is. I think, one of my favorite things about working in legislatures is how nimble you have to be, and how you have to constantly kind of be evaluating your environment and responding to it. So it's not really it's not a yes or no answer for me. I think it's, you sort of see who are the players on the board, and maybe it's a venue question. Maybe you don't do as much federal work, you do more work at the state level, or you do more work at the state court level or local level. But I think you just have to be flexible.
This is a hard question to answer in the abstract. I mean, there are some cases, they get filed in the field I work in, which is mostly church and state issues, and I think it was a mistake, right? Like sometimes advocates get out in front and they want to push an argument, and it's a loser, and they're going to make bad law. Courts are going to make bad law in those kinds of cases, and we think it would have been better not to raise them. But sometimes important issues are unavoidable. They're going to get litigated one way or the other, and then the question is, what kinds of arguments are you going to present in those kinds of cases? And this is something we'll talk about in the breakout session. But here I think you have to give arguments that you support, that you believe in, that you can sincerely advance. And sometimes those arguments aren't going to win. And we're going to take losses. Progressives and liberals are going to take losses in the courts. And there's a question about how to lose. Like, what are the good ways of losing and what are the bad ways of losing? And I guess my own personal view, and this is partly a matter of temperament, is you should lose staking out arguments that you believe in and that you think have persuasive force over the long haul, and you should be willing to state those arguments and to defend them persistently over time, and to lay out a vision, to be committed to that, and to make those arguments, to represent those values. And sometimes that's going to mean perpetual dissents, as it were, or writing briefs where you're going to be on the losing side. And that's not always tactically smart, but if you have some faith in the long-term vision, then that's something that has to be part of the way that you think about it. But that doesn't mean that you should litigate cases from on the front end that are going to make bad law. Those are hard questions. You have to think about them up front as a matter of tactics. Yeah.
Next question.
So when it comes to representing diverse coalitions in a complex legal battlefield, oftentimes different aspects of that coalition have different goals in mind when it comes to policy and when it comes to what they are looking to accomplish. I think this was very self-evident in the LGBT rights movement, where marriage was on one side, but then there was employment rights and trans protections. But once one prong gets established and wins that legal fight, that one part of that coalition sometimes tends to shrink or evaporate. So how best do we maneuver inside a legal battlefield with a diverse coalition and keep all parts of that coalition engaged following a victory for that one part of that coalition?
It's tough, but call them out, Yeah, I think, as Amy suggested, we do coalition work. We've done some legislative advocacy in New York around school discipline issues. And you make a really, really important point about where various organizations are and their missions and their goals and what they want to achieve and what they want from the bills they might be pushing or the litigation they might be bringing. I think keeping that transparency and that candor in all of your interactions with coalition members, look, this is good. Marriage equality is a very laudable goal, and we're glad to have accomplished it, but many fights on the LGBTQ front remain, and we need you all here as engaged as you were in that fight and these subsequent fights, and just, keeping the feet to the fire and telling folks, as straightforward and professionally as possible. But yeah, we need you, and we need you to sustain your support of these efforts.
And I think part of it too is sort of how you build coalitions. I think it can sometimes be a hindrance to build a coalition around a very particular fight.
Yeah.
When we do legislative planning, we might plan out sort of 5-year and beyond goals, but have discrete legislative fights along the way in the works. And I think if sort of the whole coalition is involved in figuring out, what's our big goal, and how do we make sure we're never getting in our own way in the incremental steps that we take, I think that can help. But coalitions are difficult. I mean, that is their nature. And sometimes there's always going to be that tension between groups or between goals that, the strength of having the coalition outweighs some of those difficulties and tough times. And so you just kind of plow through them. But I think that the strength of outlasting the difficulties is reflected in the fact that you're building a coalition around a very, very broad goal and not a distinct battle that you may win or lose, and then afterwards people either, walk out the door or stay in the room.
Yeah, if I can just add one piece to that, just reflections from the reproductive justice, health rights and justice coalition. Some of the strongest coalitions are the ones that have a very diverse range and making sure to bring as many of those voices, especially of those who are most impacted and those who are typically at the margins, those who are typically not necessarily centered, making sure that they have a seat at the table, that their voices are being heard and represented, because they're the ones who can note, like, have you all thought about how this actually impacts this issue? Because if you don't have that representation, you might have the best intentions, but if you don't understand how implementing something along that level might actually bring unintended consequences, some of those can be mitigated if you have those voices in the room who can represent those viewpoints. I think we have time for a couple, maybe 2 more questions.
I think this goes specifically to Mr. Epps and Ms. Woolard. I have a background in journalism, and I've been trying to, as I go through law school, explain things to friends and family, and I feel like I sound like a crazy person. How would you recommend kind of keeping that ability and improving that ability to communicate with the general public while you're like manipulated into becoming and thinking like a lawyer?
A loaded question.
I'll answer quickly, but I'd be happy to talk to you later. I've actually just come from NYU, where they have a legal nonfiction seminar, and I did an hour-long program on precisely this, where we started with an article I wrote years ago as a reporter before I went to law school about molecular biology, where I'm trying to explain to a lay audience what it is that a very sophisticated molecular biologist is doing to test the brain of a mud leech and why that's important. And the way you do that, because you're not going to be able to put in a 2,000 word or 1,000 word article, exactly what happens when people do monoclonal antibodies, and then electrophoresis, the result to find out the DNA. You use metaphor. You try to talk about it in terms that people live, right? You're not trying to bring them into law and make them sort of mini lawyers. You're trying to bring law to them. And we had a guy, when I lived in North Carolina, we had a guy who was a very successful criminal defense lawyer because he had a book that had the plot of every episode of the Andy Griffith Show, and which is a religious duty in North Carolina to watch and note. And he could always relate, his client could be the worst sort of child pornography kingpin in the world, and he could relate somehow his story to the Andy Griffith Show. This is like that episode where Goober promises Aunt Bee that he'll clean her house. And the guy had a fantastic record because he was bringing legal questions, into a field that people understood. So, the important thing is not to lose sight of the world those people live in. You are bringing your information to them, not trying to suck them into the shrill Gehenna that we live in.
That's a tough act to follow. I mean, I think part of it in my context is I have many different audiences that I have to communicate with. It's a relationship-driven business in that way. And you learn more and more. Your job is to learn more and more about your audience and figure out the best way to have them hear you. You hear the term elevator speech. For me, that's literal sometimes. I have an elevator ride from the 5th floor to the ground floor to convince somebody to vote for my bill. And so you have to be able to communicate and distill down into that time frame what you're talking about, and not just what you're talking about, not if someone were talking to you, how you would understand it, but how they would understand it. And so part of the root of that is empathy, right? Understanding where other people are coming from, even if they are people who are diametrically opposed to what you believe in. You have to find a way to have them hear you. You know, when I have to have Republicans on my bills, even if my bills don't seem like conservative ideas. How can I turn them into conservative ideas? Well, maybe I talk about, you know, the fiscal ramifications and how the state saves money based on what we might do. You know, you have to find a way in for folks. And I think for your experience in law school, putting yourselves in situations like community organizing groups, you know, sitting in task forces or organizing efforts where community folks are at the table and leading the conversation and sitting back and listening, to be honest. I mean, in law school, I think you're sort of taught to, you know, you have to rise above, right, and be the voice in the room and recognize that when you leave law school, people perceive you that way, and sometimes it's better kind of not to be the voice in the room, that you heighten an experience just by being there. And so finding ways to be in a room without being the lawyer, I think, helps as well, if that makes sense.
And then one last question.
Sorry, excuse me. Thank you guys for this panel. It's been really informative. In talking about advocacy especially at the state and local level, and thinking about criminal justice reform, I often think about what might not be a sexy issue to a lot of people, but budgets and allocation.
Love it.
Yeah. And thinking about in the criminal justice space, we don't fully fund public defenders. Prosecutors make more than public defenders, which, like, what does that mean for us? So could you guys reflect on how to advocate and organize around budgetary issues? Thank you.
Absolutely. To go back to our school, the prison pipeline work at AP, it has since evolved into a more explicit, radical push for police out of schools across the country. And part of that analysis goes into budget considerations. Like, look, you're spending $10 million on your school police force, on your memorandum of understanding with the ex-police department. This money could be going to counselors, mental health supports, PBIS for these young people to ensure they have holistic learning environments. And I think that also very much so applies to the criminal justice space, right? You know, securing equitable funding for public defender offices and ensuring that folks aren't, you know, detained, you know, in pretrial detention, unconstitutionally, all of it, yeah.
And I think part of it too is everything Garrett's been talking about. I mean, the budget is probably the most abstract, unreachable aspect of some of the work that we do, but it is one of the most powerful drivers of bad policy. Not just what we don't fund appropriately, but how we have baked in this funding cycle where we are actually funding our courts on the backs of the people we are driving into the system. So court fines and fees in general are extremely difficult to do policy around because people's jobs depend on those fines and fees, jobs of law enforcement, jobs of court personnel. They are huge components of local budgets. And so I think step one is bringing some of that into the light and having some transparency that is understandable to a lay audience around budgets. There's a movement kind of going around the country called participatory budgeting, where communities actually sort of take charge of what localities are funding and think about ways to, you know, like I said before, rebuild the entire building, even when there are people living inside. And so part of organizing around budget reform is taking it out of the abstract and making it real for folks. And whether that's at city council meetings or through community organizing organizations, I think that's really the forefront of a lot of